We are going to discuss questions number 61 to 70 that were posted on the Telegram channel. If you wish to check the channel out for all these questions, please see the link in the description of this video. Let's get on. The question number 61 was this: which of the following statements is or are correct regarding the nominated membership in Parliament? Statement 1 says to nominate or not to nominate the members in Lok Sabha is a matter of discretion for the government. Now, we know that the nomination in Lok Sabha used to be there for the Anglo-Indians. Now, this has been removed by the 104th Constitutional Amendment Act, which came to force on 26th January 2020, whereby the reservation for scheduled caste and scheduled tribes has been extended by 10 more years, that is until 2030. The nomination option for the Anglo-Indians has been removed. But while it was there, it was optional. Okay, so please ensure you understand clearly who are Anglo-Indians also. That is provided under Article 366 Clause 2. So you may like to read that. So this is actually a wrong statement. Second statement says to nominate or not to nominate members in the Rajya Sabha is a matter of discretion for the government. We know there are 12 members to be nominated by the President of India. Is that on the discretion or not of the government? That means if they want, they will nominate, otherwise they will not. Now for this, if you quickly go and read Article 8080 of the Constitution, it very clearly says that Rajya Sabha shall consist of 12 members. It shall consist. There is no option for the government to nominate or not nominate. They have to. So this is also wrong. Hence the correct answer here should be option D, that is none of these. And as you can see, the performance on this basic idea. But anyway, I think at that time you may not be aware about the 104th Amendment. Moving on, the next question that we have, question number 62, which of these categories of citizens are not eligible to contest elections to the Parliament? Now, if you see, the first one says under trials. Now, under trials are those people who are undergoing their trial. The prosecution is under process. So nothing has been proved yet. But for various reasons, including not having the security for the bail, they are in prison. So there is no restriction on them, and they can definitely contest the election. So this is not the correct answer, because they can contest election. Persons detained under prevention detention laws, they are just detained for preventive detention purposes. They can also contest election, and this is also a wrong answer to this question. Then it says persons convicted in any offense. Please mind the word any. I'm sure we know that for criminal offenses, a person can be disqualified from contesting election. But if you know the real provisions under Section 8 of RPA 1951, there are different categories of criminal offenses that result in disqualification. There is no blanket ban that you commit any offense and if you're convicted, you'll be disqualified. For certain offenses only it is done. So when we say any offense, then it is not going to disqualify you. Hence, this is also wrong. So the correct answer for this should actually be none of these statements. Moving on, the next question: which of the following statements is not implied by the proportional representation system of election for the President of India? I'm sure you have revised your topic of election of the President. In this case, let's quickly see the options. All the MPs have equal value of their vote. Yes, this is correct. Naturally, because the entire Parliament is considered as one unit. Moving on, the MPs and MLAs representing the same state have equal value of their vote. No, this is not correct. Logically also, if you see, the MLA constituency is smaller than the MP constituencies. So even theoretically, you can understand that the value of the vote of MLAs will be slightly lesser than the value of the vote of MPs in the same state also. So this is actually the wrong statement, and hence the correct answer for this question, because it says which is not implied. Let's see the other options also, just for the sake of it. All MLAs from a state have equal value of their vote. Yes, because the constituencies are so designed. That's first. And secondly, even the way it is calculated, the entire state is divided into the number of the constituencies, so the population is divided by those many seats, so all those representatives end up getting the equal value. You can see the formula also for revision. Then the fourth statement says the value of vote of all the MLAs is equal to the value of vote of all the MPs. Now, of course, if you want to put little extra logic into this, you'll see that of course it is the elected MPs and elected MLAs. But in the spirit of the question, you need to see that out of these options, if you have to give a benefit of doubt in case there is some subjectivity, you will still consider this as a correct statement. Because ultimately in the election, it's only the elected MPs and elected MLAs who vote. So with that spirit, we get the correct answer to this question is option B. Next question was, which of the following provisions are mentioned in the Constitution of India? Please mind it, mentioned in the Constitution of India. First says motion of no confidence. Now we know that this is not mentioned in the Constitution of India. It is through the rules of the Lok Sabha. The term no confidence has never been used. Second, vice president to hold office for a term of 5 years. This is absolutely mentioned. If you want, you can read Article 67, where it says that the vice president shall hold office for a term of 5 years from the date on which he enters upon his office. Third statement says vice president shall discharge the functions of the president while the president is unable to do so due to illness. Absolutely correct. And this is pretty much the reason why the vice president's office has also been conceived. You might like to go through Article 65 quickly on that issue. So the correct answer here should be second and third statements. Moving on, question number 65 that was posted on the channel. Which of the following hold office during the pleasure of President of India? This is a very important question from all your perspective because all of you are going to join the civil service. So if you just go and read Article 310, a very important article for all of your preparation and career in civil services part of the Constitution, you'll see that civil service and defense service, they both hold office during the pleasure of the President of India. So this was not that difficult, but performance somehow has not been that good. Next question was, which of the following directive principles of the state are reflection of Gandhian principles? Now, please understand that Gandhi's principles would generally talk about things like grassroots empowerment and democracy for the depressed classes, and also anti-intoxicants, things like that, Gram Swaraj, cottage industries, cooperatives. These were the ideas which we consider as Gandhian principles. So keep that in your head if this kind of a question comes. In fact, this is a question which came in UPSC. This is a real question, slightly modified just in the options actually. So if you see promoting cooperative societies, as I told you, it is a Gandhian principle. Then promoting cottage industries in rural areas, this is also a Gandhian principle. Excuse me. The third one, securing participation of workers in management of industries. This is not a Gandhian principle per se. This is more of a socialistic idea that is implemented here. Similarly, the fourth point, providing legal aid to the poor. This is also more of a socialistic thought, not so much of Gandhian principles. So 1 and 2 only should be your correct answer. Moving on to question number 67, which of the following statements is not correct regarding an office of profit under the government of India? So here we are with the perpetually irritating area for aspirants, the office of profit. Before answering this question, let us learn today in brief what is this office of profit. I shall be preparing an explanatory video separately for office of profit issue, discussing it in detail later. I will definitely post that when it's available. But today let's briefly see it. The concept of office of profit essentially comes from the idea of separation of power, especially the separation between the executive and the legislature. The members of the legislature shall not hold any post in the executive, else there will be a conflict of interest. So if we want to define what is office of profit, I try to put a definition here for you. As I always say, you should always try and define things in one line. So it's any position other than political filled by either election or nomination for which the person draws a profit. So essentially there are three aspects. There should be an office, it should be under the government, and the holder shall derive some profit out of it. Office under the government with a profit, right? Of course, in a parliamentary system that we have, there's an exception that the members of the legislature, they can hold one office into the executive, and that office being of the ministers. Because we don't have a complete separation of power, and that is why this idea of office of profit becomes very important, that except this one post, there should not be any other kind of profit you should have from the government, otherwise you'll fall into conflict of interest. Please understand that the exception from disqualification does not mean the office itself is not an office of profit. Okay? So the question we must understand now is, how do we know if an office is under the government or not? Is it an office of profit? So for that we have this case Shivamurthy versus Andanappa, where the Supreme Court has given 4 tests to understand if it is under the government or not. So if the government makes the appointment, if it has the right to remove or dismiss, if the government pays the remuneration or exercises any kind of control over the performance of the functions, then it shall be considered as an office under the government, and that should be sufficient to disqualify the person. I would also direct you to an article on the PRS website, PRS blog. You can go and search there simply law on holding offices of profit. As I told you, I shall be bringing out a detailed video later. This was a quick introduction to office of profit. So now let's answer the question. Which of the following is not correct regarding office of profit? Members of parliament are not holding an office of profit. I just told you a political post like that is not considered an office of profit. So it is a correct statement, hence a wrong answer for this option, this question. So, because it says which is not correct. So this is a correct statement. Vice Chancellor of an university of the state is not an office of profit. Now see, this question I put so that you can learn a few things. However, this was straightforward because the question is asking office of profit under the government of India, whereas Vice Chancellor is University of the state. It definitely is not an office of profit under government of India. So answering this question, I did not want it to be difficult, but I'll highlight you to some learning here. So there is a case by the name Jyoti Prasad Upadhyay versus Kalka Prasad Bhatnagar. Kalka Prasad Bhatnagar. Kalka Prasad Bhatnagar was the Vice Chancellor of Agra University, and he was going to contest election for the Legislative Council of Uttar Pradesh. So anyway, in this question, the court very clearly has held that the Vice Chancellor of the Agra University was not holding office of profit either under the state government or even under the central government. Essentially because when the Chancellor appoints, Chancellor being the governor here, appoints the Vice Chancellor, he is not acting in an executive capacity. So there is no executive control as such in this case. So anyway, this is also a correct statement. It is not an office of profit, hence a wrong option for this question. Then President does not act on the advice of Council of Ministers on questions regarding disqualification of MPs. I am sure you know, you're learning that this President in this kind of situations will act on the advice of Election Commission. So this is also a correct statement and hence wrong option for this question. So the correct answer for this question should be none of these. All of these are correct statements. Looking at the performance, I definitely need to make that video for Office of Profit. In some time it will be available on this site. Okay, next question. Which of the following statements describes a private member's bill in Parliament of India? This is a very straightforward question. I'm sure you know private member is a member of the House which is or who is not a minister. It does not matter which party, the person may be from the ruling party also, but as long as they are not holding the post of a minister, they are a private member and their bill will be called private member bill. Otherwise it is called a government bill or a public bill, sometimes even a treasury bill in some countries. So the correct answer here should be B, not that difficult. So question number 69, which of the following statements best explains a two-party political system? A very basic question. that what is a two-party system. Now, let's see. In any democracy, you cannot have just two parties. Even if you say China, which is not really a democratic country, it's a one-party rule. Even they have something like 6 political parties, but all of them are under the overall umbrella of the Communist Party of China. So there will always be multiple parties, because democracy means multiple opinions, multiple thoughts, and different ideologies. But what happens over time? Just two parties start dominating the government, right? So it so happens that either it is the Democrats or the Republicans in the American system today that you will see they will take control not just of the presidential office, but even their legislature, even though there are many other parties also, similarly in the UK as well. So please do understand that two-party political system does not mean just two parties. It means multiple parties with dominance of two parties, or even in a way two ideologies or two schools of thought. So all the parties congregating around themselves. So that's your two-party system. The question number 70, which of the following provisions have not been expressly provided in the Constitution of India? Not been provided. I think in these 10 there are so many not questions. Not provided in the Constitution of India. Let's see. Number of members of the Finance Commission. I'm sure you know Finance Commission is appointed through Article 280. If you see, it very clearly says there shall be a chairperson plus 4 other members. So the number of members is prescribed there. Number of judges of Supreme Court of India. If you go and read Article 124, specifically Clause 1, it says there shall be a Supreme Court of India consisting of a Chief Justice and until Parliament by law prescribes a larger number of not more than 7 other judges. 7 other judges. Of course, today it is much more than that, but the number is specified there. Okay, so the number is specified here also. In fact, you should know there is an Act of Parliament now, the Supreme Court Number of Judges Act 1956, which was recently amended as well to increase the number of judges to 33. So that's 33 plus 1 Chief Justice, total 34. Third option says number of members of the Union Public Service Commission. Now this has actually been provided in nowhere, not even in the Constitution or in the Act. It simply says that such other number as the President decides. In the Constitution of India, you will see that it has not been provided for UPSC, and hence this is a correct option for this question. UPSC is your answer. Then in this video, I thought I'll leave you with the essential Indian thought behind secularism. Sarva Dharma Samabhava. I'm sure you understand the meaning of that. But sometimes people dispute that this is how this is possible. It depends what that particular religion preaches. Well, yes, that's correct, and that's why I will say conditions apply. So I'll see you in the next video with question number 71 to 80. Till then, study well. Thank you very much.